Going to court can be overwhelming and intimidating. This video will help you understand how you can prepare for court in West Virginia and what to expect when you get there. This is general information about representing yourself in civil cases like divorce, custody, or a problem with the landlord. Either you filed paperwork to start your case, or you filed paperwork responding to a case filed against you. Once the appropriate time for responding to the paperwork has passed, you should get a notice of hearing telling you when and where a hearing will take place. If you haven't heard about a hearing date, you can contact the court's office staff to ask about scheduling a hearing. If you don't know which court to contact, look at your court paperwork to see what court you are in. If the issues in your case are about your family relationships, like divorce, child support, or custody, your case likely belongs in family court. If it is another kind of civil case, then you will either be in magistrate court or circuit court. Now, let's discuss how you'll prepare for the hearing. To prepare for your hearing, read all of the paperwork filed in the case. It is very important you know what is in the documents. It is your job to prove your case to the judge. Unless you have a lawyer, no one else will be there to prove your case for you. Remember, you and all witnesses will be under oath, so it is very important that you and your witnesses tell the truth. You will need to get everything together to prove your case, and this is called evidence. Evidence can be witnesses or people, or paper, pictures, or video. Witnesses are people who come to the hearing to testify. Witnesses can be people involved in the case like yourself, or they can be people who saw what happened with their own eyes or heard what happened with their own ears. You cannot use letters or written statements from witnesses to prove what happened. All of your witnesses must be present to testify at the hearing. Make sure to tell your witnesses ahead of time when they need to be at the hearing. It is your responsibility to ask questions for the witness to answer. Before the hearing, talk to your witness. Make sure you know what they will say. You should outline questions ahead of time to ask your witness, but be sure to keep the questions short. Make your questions to your witness who, what, where, when, and why type of questions. The other side can also ask questions of your witness. Evidence that is a paper or document, picture or video, can be anything that helps your case. It might be a lease, a deed, medical records, phone records, a video of your apartment, or a picture of a bruise left on you. You should bring 3 copies of all paper or picture evidence. If you have pictures, videos, texts, or emails on your cell phone, bring the phone and all printed screenshots if you can. Now you've prepared. So what will it be like when you actually go to court? First, make sure to dress nicely, like you're going to a job interview. No shorts or tank tops. Make sure you aren't chewing gum or tobacco. If you have children, have someone watch your child while you are at the courthouse. Follow the court's rules about cell phones. Either turn them off or put them on silent, depending on what the court staff tells you to do. Make sure you arrive early to the hearing. Look up where you should park ahead of time and see if there's a cost to park. You'll have to go through some type of security once at the courthouse. Be at the courthouse at least 15 minutes before your hearing is set to start. You should check in with the court staff to make sure you are outside the right courtroom. Some cases may take longer than expected, so be prepared to wait. During the hearing, generally, be prepared to tell the judge in a few sentences what your case is about. Second, tell the judge how you plan to prove the facts of your case. Only tell the judge facts that are relevant and tell the judge the most important things first. Write down what you'd like to say ahead of time. This is when you offer to show the judge documents or evidence you have. It can be helpful to have the parts you want the judge to look at highlighted if you have a lot of evidence. Lastly, as you finish presenting your case, be sure to tell the judge exactly what you are asking the judge to do. The other party will also get a chance to present his or her case. You should not interrupt or argue with what the other party is saying when it's their turn. But if you disagree with what they are saying, you can object to what they are saying. You can raise your hand or tell the judge you object and disagree, but give the reasons why you are objecting. If the other party has a witness testify, you can ask questions of their witness. Be respectful before and during the hearing. The judge will be observing, and behavior impacts whether the judge believes what you are saying or not. This doesn't mean you should be afraid to speak up. Do not depend on the judge to remember everything you've asked for. If something is overlooked, tell the judge. If you're not understanding something, ask for clarification. The judge may make a decision at the hearing, or the judge may need time to decide. You will get written paperwork letting you know what the judge decided, and this is called an order. Orders will lay out the judge's decision and will be signed by the judge. The order will have lots of important information. If you are considering an appeal, talk to an attorney beforehand. There is only a short window to file an appeal after a final order has been entered. Before going to court, talk to a lawyer if you can. Even if the lawyer can't go to court with you, the lawyer can help you understand your options and tell you how to prepare. To apply for free legal help from Legal Aid of West Virginia, call our office or visit our website to apply for help online.